and welcome. It's great to have so many of you joining us. Our timely topic for this morning is today's trends and best practices to reduce hiring risk. And as you've probably figured out by now, we're going to be focusing on the fascinating world of background screening. This is a topic that, and this is not the first time I've found myself saying this about this topic, but once again, it's ripped from today's headlines. There's so much going on in this field, in this practice, both from a compliance perspective and in terms of best practices, no doubt for your specific organization and for your industry, I'm sure, as well. The man we call on to enlighten us on this critical topic really needs no introduction to employers group members, but I'll give one anyway. Alan Lange is a senior vice president at Universal Background Screening. He's very well known to many employers group members based on the numerous webinars we've done over the years, and Universal Background Screening's presence at our employment law updates every year, and Alan's much ballyhooed presentation last year at our employment law update in November. And I've had the pleasure of working with Alan for, I guess it's about 7 years now. And I can attest on a personal level that you will not find anyone more knowledgeable and really more importantly, passionate about background screening and able to understand it in a way that all of us actually know what he's talking about. We can all understand it, which is something I really appreciate. And I know that I, as all of you, I'm looking forward to learning a lot today about this topic. I think in particular, I'm looking forward to learning about fuzzy logic. Finding out if that's something background screening has cornered the market on, or whatever the story is there, because I know that that's going to come up in our discussions this morning. And because I know Alan's not going to want to brag too much about Universal, I'm going to do some of the heavy lifting for him on this. I could go on for a long time about it, but basically, as you guys probably know, Universal Background Screening is absolutely amazing to work with. Dozens, by now probably hundreds of our members have worked with Universal Background Screening, and I can say literally without any pause, without any hesitation or reservation, that these guys are absolutely fantastic at what they do. I have had literally nothing but 100% positive feedback about every interaction our members have had with Alan and with everybody at Universal Background. So let's get the show on the road. I'm going to turn it over now. I'm anxious to hear Alan's updates and his insights. I'm sure you all are too. So right now I'm going to turn it over to Mr. Alan Lange. Take it away, Alan.
Thank you, Bill, and thank you for that introduction. And thank you all for joining us today about compliance and consumer reporting or background screening. As Bill said, we definitely want to make it as interesting as possible, and definitely with some feedback from you with questions that you could type in and that we'll also answer at the end of the presentation, since there's a lot to review. As you see on the topics on your screen, we're going to go over briefly the process of screening, going over the legal compliance and updates pertaining to nationwide, but also to California specific, since there's quite a few. Also about the compliant forms that are needed, which is really important. Talking about ban the box, which is that question, have you ever been convicted of a felony or misdemeanor, and where you put that on an application or when you ask that, since it's changed quite a bit, as well as current trends. So again, definitely want to hear from you on your questions. And not to spend much time on this one slide, but as Bill stated, we've been a preferred partner of Employers Group since 2011, and we value that partnership. We do provide, as a value, discounted rates, deep discounts. We waive all setup fees, and we have a dedicated representative and a dedicated customer service team that would be working with you. We do focus on regulatory and safety-sensitive populations nationwide and internationally. We are very proud, as Bill stated, voted 8 years in a row as top in customer service and quality of service. We are one of only 9% of the accredited firms in the United States through the National Association, and we do care about personalized care and, of course, the importance of turnaround time, which we'll talk about today, because that's a real important topic, about turnaround time, yet also looking at compliance of how fast we can actually conduct searches as humanly as possible. And just to mention that we have offices in all time zones, and we have 24-hour assistance as well. And now to get underway, first to talk about the fact of when working with a consumer reporting agency, so Universal is a consumer reporting agency, and conducting background checks, it's important to understand that no matter what throughout the U.S., there is a federal law called the Fair Credit Reporting Act that many of you, I'm sure, know. This Fair Credit Reporting Act was enacted by Congress in 1970, and it's had a few amendments to it. But overall, it's to ensure accurate information is reported and to restrict how much information can be reported on a consumer, and also to provide that consumer a dispute mechanism just in case it's a false positive. And we'll talk more about that as we go. To get into some of the most common core services and how they operate, once in a while we'll get a call and someone will say, hey, I just want a background check or a criminal background check. We wish it was that easy, but it's not, because there are so many different layers that you can add to a package to look at that scope of who that individual is, because one layer would not be enough. Unfortunately, the court system in the United States is decentralized, so we have to go to different places to pull different information. But it always starts at the foundation with a Social Security alias trace. And what this is not from the Social Security Administration. It's actually a group of aggregated data that's tied to the Social Security number that shows previous, current, and historical address information, so we can find out where a candidate has lived, but also the alias names they've used that have been collected over the years from credit headers and other database information. Now, our industry basically uses that as the identity tool to then figure out the next steps in what we want to search based on that individual or what they didn't report. For instance, one of the most important aspects and key searches and services is the county criminal court search. So just to let you know, there are 3,300 county criminal courts in the United States, which is different than the municipal courts. So municipal courts that are local courts, there's over 36,000. The background screening industry, we focus on the county criminal court searches because that's where a majority of the records that would be reportable and that you'd want to know about are. And in these 3,300 courthouses nationwide, 40% of them are still needing a court runner and their court clerk reviewed, meaning that we have to send a court runner into the courthouses, and the court clerk will take that information and then look it up. You would think by now it would all be database and automated, but it's not. So a really important aspect, because we'll talk about this later, is that 40% of the courthouses we still send court runners into, and that all court records are kept by first and last name as a primary identifier. The secondary identifiers are the Social Security number, middle name or initial, and the date of birth. Now, we wish it was the Social Security number that was the identifier, since that's a unique string of data. However, courts have and legislators have fought against using the Social Security number, and the courts are still set up to be first and last name. So if we have a John Smith, a common name, we're going to get a lot of false positives we have to look through to start the process. But we do that, and we'll talk more about the vetting of that. Now, when organizations try to cut this corner and not do a county criminal court search, you see the cases here, and again, we'll give you the deck of slides. These are just a few of the cases that make the news that are very unfortunate, because for the first one, as you see, a home care aide accused of stealing from a client, they had 18 counts of criminal impersonation and 11 counts of 6th-degree larceny. Or the last case in Arizona, unfortunately, a cable company in Arizona had someone go into a home that had 16 prior felony convictions and 20 years in prison, which they would have found out if they actually ran a county criminal court search. In that case, they only ran a database search, which of course missed that information because it wasn't the most up-to-date and accurate as a county criminal court search is versus a database. And we'll talk more about that in a moment. So again, the county criminal court search, especially in California, because California does not have a statewide, so it is extremely important to make sure and you run the counties if you're a California organization or have business in California. As you see here, not all states have statewide criminal searches, California being one of the 6 that does not have a statewide. In California, we do have a fingerprinting system to look at state information, but we'll talk even more about fingerprinting in a moment. So the best practice would be a 7-year county criminal court search, which we can get those 7 years of where the candidate has lived in the counties based on the Social Security trace we talked about. Now, with statewides, in those states that do have statewides, they're not always so accurate. Some of them are and some of them are not. So it's made the news over the years of Texas and Florida not having all counties reporting into it. So you don't always get all of the information. But it is another form of a service that we can provide outside of California in those states that do have statewide, and to find that information that's reported into it. Again, it's by first and last name as primary identifiers to pull that information. Another layer is the federal criminal database search. So the feds don't share their information with the counties or the states, which means that we also have to pull the federal information if we want to find out federal cases such as extortion, racketeering, mail wire fraud, credit card fraud, counterfeiting, child internet pornography, and interstate crimes. So believe it or not, those cases do not make the counties or the states. And in fact, we've had a few cases that we've seen of those clients that run federal national criminal or federal 7-year criminal, where we found a murder, grand theft, and drug trafficking that never made it to the counties or the states because of the fact that the feds didn't, of course, report it. So it was very helpful to run the federal criminal database search within the package, and we can do that and bundle it. Another layer is also we call the USA Criminal Search, which by other organizations is called the National Criminal Database Search. So even though it's called the National Criminal or the USA, it doesn't include all of the United States. It's very spotty, but it's the best of the databases that are out there. So what's nice about the database is that we consider it a lead generator. So if you're running your counties or states and you're running this criminal database search, what you're going to find is maybe a place that they have not lived but conducted a crime that's in this database, and then we can find that information out and then vet that information at the local county if something comes up. Again, it's by first and last name, so we can have false positives. In addition, the USA Offender Search is the national sex offender search that covers all sex offender registries, which is a very important search if you have parties at risk, and we can run that. And the third, the USA Security Search, is the terrorist watch list. It's also called has the OFAC in it, which is the Office of Foreign Assets Control. It's where any terrorists or FBI most wanted would be within that database. What's important about all databases is that this information has to be vetted by the background screening firm. So you'd want to make sure that your background screening firm is looking for any false positive information before reporting that to you. Unfortunately, with Calvin Klein, they had a $716,000 settlement for using data dumping information from their background screening firm without looking at that information first. So it's really important you make sure that your background screening organization looks at this information and weeds out any false positive information before reporting it to you. And as Bill stated, fuzzy logic and what that means. So you always want to make sure that the police also call it, or the enforcement officers call it Boolean logic as well. So fuzzy or Boolean logic means that we're looking at variations of someone's first name, because someone can hide behind their first name based on the variations of how it's spelled or how it's stated. Because, as we said, all court records are kept by first and last name as a primary identifier, we want to make sure that we have the accurate first name, which is different than an alias name that we'll talk about in a moment. So I've seen cases of Mike versus Michael, or Kate versus Catherine, or Tim versus Timothy. You want to make sure that your background screening firm is only taking the first few letters of the person's first name to look at any variations and to run all those variations at the courthouses by giving them only the first few letters of the first name and the full last name. That way we can catch more, and we have caught more by doing that. So you want to make sure your background screening company is not just doing an exact name match search. You can ask them that. Extremely important that you're doing this fuzzy logic. We do it, for instance, at Universal wherever it's available nationwide. So we catch a lot more information to reduce risk. In addition, then there's another layer, which is an alias name. So we just talked about fuzzy logic, which is the first name variation. Now we're talking about a different name. Sometimes it's so my full name is Alan Stewart Lasky. Some may go under Stuart Lasky, right? Because that could be a variation. That would be considered an alias name. So it's really important to, for best practice, is to run alias names, which you can bundle within a package to catch any alias names that they lived at their counties or the statewide or federal. All of those can look for alias names as well. Because although there are cultural and accidental reasons why another name may be on a social security trace, we do know that people use it to hide their true identity if they're very savvy applicants. And we've seen this over and over again. You may have all seen in the news just this year that there was a Uber self-driving vehicle and a pedestrian was killed. They still had a person within the car that was operating the car, and unfortunately what came out in the news is that person in the car behind their alias name did have a criminal record and was under a different legal name and served 4 years in prison. So that made the news even worse for Uber, and we'll talk more about Uber because there are some important information about case law that's come out of Uber's background screening that we'll talk about in a moment. And then as you see in the second case, a woman arrested 396 times with 83 alias names. It is very easy to change your name officially, and it's extremely important, again, for best practice to also look at the alias names of an individual, which we can bundle in a package to catch more information. And to put all this information we just talked about with the criminal-oriented services, you know, this graph indicates how background screening is set up in kind of a bundle that you can create. The first level and layer, as you see, are the county criminal court searches that we can run through the Social Security trace to find all the places they've lived for the past 7 years. In addition, if there are statewides available, not in California, but in other states, we can run those, but some of those statewides are not that great because they are not all the counties report into them as represented by the holes in this graph. And then we do have the federal criminal database we talked about, the multi-jurisdictional criminal database, such as the USA Criminal Search, the sex offender search. We then can, which we'll talk about, run motor vehicle reports and verifications, such as employment and education, to find more information about that individual, which gives us more of a view, a broad view of who that individual is, and we can catch more information that way. Now, there may be certain ones of you that have to do fingerprinting, because in some different types of jobs and positions, some in education, healthcare, in certain instances, there are mandated fingerprinting that needs to be done. You would think that fingerprinting would be accurate because of the fact it's through the Department of Justice and state police, but unfortunately, ever since July of 2013, a National Employment Law Project study found that it is not accurate, and in fact, it's missing 25% of all crimes in a fingerprint and 50% of all final disposition information, as reported by the U.S. Department of Justice, who testified before Congress. In addition, there have been other articles about how poor the fingerprinting system is, with 73 airport workers with possible terrorism ties passing the TSA background check fingerprint, and even Ohio admitting to failures in the state's technology and the need for additional staff. And I'm sure you've seen in the news the horrific events that have occurred over the last year, 2 years, 3 years, about the shootings in schools. And what that ends up doing is creating, rightfully so, more laws pertaining to the regulation and more individuals wanting to fingerprint. The unfortunate part of that is that the states do not have the funds to make their fingerprint system more robust, which then delays fingerprinting more and more and also causes more failures. So this issue is not going to go away anytime soon. A lot of individuals who have to fingerprint, we always recommend best practices to do a supplement with a private background screening firm in making sure that you don't miss anything, even if, again, fingerprinting is mandated. And talking about behind the scenes of criminal information, we are asked this a lot about, hey, well, what do you report? How far back can you report? Which is really important information. Now, from a federal standpoint, to start off with, there is no federal limit of how far back we go for conviction-based information. But if it's non-conviction-based information, negative information that can appear in a court, a docket for an individual conducting some type of being arrested and then going toward conviction, we can report 7 years of that information. Again, with conviction-based information, we can go. There's no federal limit. Now, that's important to know. There was a $900,000 settlement by a firm and the background screening firm due to the fact that they reported over 7 years of negative information that was non-conviction-based information, which, again, ends up in court if your background screening firm is not careful with this information. You always want to make sure you're with a background screening firm that's careful with this. And a background screening firm that understands state laws. So there are also specific state criminal laws of what we can report. And I'm sure many of you are familiar with California law is a 7-year time limit, and it's conviction-only information that's allowed to be reported. Now, why this is important of looking at each state is that although we have federal law that says you can go back as far back as possible, California law states you can only go back 7 years, and that supersedes. So you want to make sure your background screening firm is doing a few things with this information. If your organization resides, let's say, in Arizona, but yet you have a California presence, and your Arizona firm HR is hiring someone in California, you would still want to use the 7-year time limit, conviction-only based time limit of information, not what Arizona is, which is going back as far back as possible. You always want to take the most conservative approach of where the organization resides, where the candidate resides at the time of hire, and where the location is where they're going to work. Your background screening firm should be helping you with that, so they're only providing you information that is reportable based on law. Also, the exemption column at the end is always an interesting one. There are certain states that have a salary exemption, meaning that if a candidate makes less than that amount, you can only go back 7 years, but if they make more than that amount, you can go back past 7 years. As a default, for instance, Universal, if we don't know how much they make in those states, we'll always just default it to 7 to protect our clients, so you'd want to go over and make sure that your background screening firm is providing these best practice procedures to reduce risk. And talking about employment and license and education verifications, SHRM, which is, I'm sure most of you know, is the National HR Association. They reported in a survey that 70% of college students would lie on a resume to get a job. It's one of the #1 areas that someone's going to lie on a resume or lie within a background check. 26.5 stated in an AOL study that they would or did lie on a resume, with over 46% of the resumes containing some type of falsifications as reported by Robert Half. With the rising tide of, I'm sure many of you have seen an email or two that have come over to you that says, hey, get your PhD in one day. There are more than 50,000 PhDs purchased each year by diploma mills. And also, there was a bust in Pakistan where there were 370 education websites operating to give out degrees from Columbiana instead of Columbia University, or Berkeley instead of Berkeley. So again, it's a very important part of looking at an individual candidate by doing verifications, and your background screening firm should be able to help you with that if that's of interest. What has changed as a trend, and this is just in the last year, is the restrictions of not asking for salary verifications. So as you see, California is one of the states that has a restriction for not asking about a person's salary before they start. This, we believe, as you see here, it's Massachusetts, Philadelphia, Oregon, Delaware, New York. We do believe eventually this will be a federal law, as it always happens this way, by states first starting with their own bills and laws and regulations, and then the federal government coming in and making it and superseding with a federal law. So you'd want to be very careful and speak with your legal about best practice if you're asking for salary verifications. And, you know, motor vehicle reports are an important part of looking at an individual to see about a person's character. If someone has 5 DUIs, 3 failure to appear in courts, and carrying substances in cars, because that will be reported too, of drug in auto, you'd want to know that, and that you are allowed to use as per federal law. So as you see in this one case, a man pulled over for speeding with 80 driver's license suspensions and revocations and 57 of his license. and it's been revoked 20 separate times, this person you probably don't want driving for you. So again, this can be another thing that can be added to a background check if helpful. Of course, if they drive for you, it can be added in a separate package. But again, and what's interesting that many don't know is that motor vehicle reports normally, as an average report, only 36 months of activity in the report, and then it drops off. Now, we've talked about all of this information from criminal and verification information. In one SHRM study, it was found that with 43% surveyed stating that reducing delays in the hiring process is the top screening challenge. And we get that. I mean, the urgency of getting, especially in this market, making sure that you keep a candidate is extremely important, and we get that. What's concerning to us is that employers in the study were willing to sacrifice accuracy and depth for a screening solution that was based on a faster turnaround time. We wish that there was a magic wand that you can get information back as quickly as possible. A perfect example is San Diego, which is now currently taking about 5 to 10 business days to get the information back because they've had changes in their courthouse and some cost cutting. So unfortunately, there are certain counties, such as also San Luis Obispo, that do take longer because of their antiquated ways of doing things. Now, there are some background screening firms that say we can do it in a day. Those background screening firms are just running a database search, which is dangerous because it's missing information. There's no misdemeanor information in it, and it's not the most up-to-date and accurate. But they're not telling their clients that. So this is kind of a case in point. Many of you may have heard about the Kalamazoo shooting with Uber. It happened a few years back. During that time, Uber reported in an article, we do the gold standard of background checks. We run a database search, and whenever we find anything on the database search, we then go to the counties. Well, that's really the cart before the horse, because again, they're only running a database up front, not a county criminal court search or a statewide search up front. They wait until the database comes back to then determine what they're going to run. Due to that, and over the last few years, they have been in an $8.9 million settlement for running inadequate background checks. An investigation determined that they hired nearly 60 drivers with prior felony convictions, even though they supposedly do the gold standard of background checks. Even in June of last year, there was an attempted murderer who was 16 years in prison and assaulting 2 women. And again, that person was supposedly background checked. So, the district attorney in Uber's hometown of San Francisco said that their background screening process was completely worthless. It ended up in a $10 million settlement for running quote unquote bad background checks. Now that is case law for everybody else. All other employers now, that can be used if not conducting a proper background check and only running a database search. So it's really important to speak with your legal about best practice, also your background screening company, about what best practices so they can help you out with your program and what fits your organization and job positions. Lyft also got hit with a settlement of $500,000 for the same reason of running bad background checks. And
Alan,
again, yes, please.
Alan, this is Bill at Webinar Central. Quick question for you. When you're talking about the quality of the checks, and probably anything in the recent era is not as difficult to find, but what happens when you're looking, this is a question from our audience, when you're trying to confirm, let's say, a college degree, diploma, from something that could be 30 years prior to the internet era, that could go way back, how difficult is that? And do you have a sense as to why it's not uncommon for background checks to come back as not verified on educational backgrounds?
Yeah, so very good question. Verifications are one of the biggest pain points, I think, for any organization because of the manual nature and the way that we have to process that information as a background screening industry. I've worked in, and this is something that I didn't say up front, but I've worked for 2 other background screening firms in my past, so I'm very aware of the pain points in the industry itself, and the verifications of education are always one of them. When you're looking at something so far back with a verification, many times with the administrator's office, because we do primary source verifications, meaning that we go directly to the source and not to who they tell us to go to as a candidate, we'll go to the source, and the administrator's office may have to go to a file cabinet somewhere to pull that information that's off-site. In those situations, we will hound them until we can obtain that information. We also do have an excellent database of information of school systems, so we can obtain it quicker if we don't have all the information, and know where to go, because sometimes they'll direct us to the National Student Clearinghouse database, which a lot of schools use, which does make it easier. And sometimes we'll even find when we're pulling the information that it's under their maiden name, but they gave us their current last name. So those are types of obstacles we deal with. If we are not able to verify that information, it's reported as the school states that it's not able to verify. Your background screening firm should allow the access to what we call candidate contact, which we do for our clients, where we contact the candidate to see if we can get any additional information from them to obtain that information on a verification. What we can't do, unfortunately, is just look at their diploma or their information, because, of course, Photoshop is so excellent, and there's so many artists out there that are so good at plagiarizing or copying or, again, fraudulent documents. So we have to go to the source, and it can become a pain point, especially with high schools, which usually take a little longer, as well as a GED or homeschooling. So they are tricky, but again, your background screening firm should always be acting with urgency to try to get that information, and should always be around to answer those questions.
It's really interesting. I think a lot of what you're telling us too is that there's still a lot of old-fashioned detective work that needs to be done in this. Interesting, that you've referenced at several points, actually going to physical files and pulling out actual papers, not just looking online.
There is, and that's exactly, as you see on this slide right here, the reason for delays, number one is mercy of the court, antiquated courthouses, and also with schools that are antiquated. So, some make us mail in a letter. If there's a potential hit on a John Smith, we have to sometimes mail a letter to this court, and the court will say it's going to take 1 to 2 weeks. That's just our policy. Don't call us. We'll get back to you. We just wait at least a week before you contact us. It's frustrating for us and for you, because of the fact that, again, we want to get that information back as quickly as possible. As I mentioned, San Diego is one of those courthouses that we're having issues with. Everyone is, just because of the process. It's also due to layoffs. Also, with the crazy weather we've been having, for instance, a perfect example was Puerto Rico, where, like with the motor vehicle reports, they were actually underwater for a while. So we couldn't get anything from them because of the fact that it was closed.
That's really interesting that you mentioned that too. What happens with other countries if you're trying to verify education, and there's a lot of countries out there and a lot of different types of educational institutions? How do you handle that for international verifications?
Internationally is a little more tricky, because the U.S. it has the most emphasis on background screening. Most countries don't care as much and don't use what we use as a system of review and checks and balances in the same way we do. So when we many times go to especially an educational institution internationally, it's even more antiquated. In Latin America, I know that there are many educational institutions, upon research, that have it in a cellar, in a file cabinet, and they decide if they want to give it to you or not. It's really that antiquated. It's really a question of chasing that information. It usually takes 2 to 4 weeks internationally. European countries are a little easier, but again, we make the best effort to obtain that information, but it is much more difficult to obtain, especially with some schools that have closed and they're no longer there, that we have to just report back that information.
Great. Yeah, it sounds a little bit more challenging too. One other question is, as you move through the compliance pieces, is for DMV checks. Do you recommend, or is there anything that we should know about for somebody who does not have a driving responsibility for their company? Is it still okay to run a DMV report? Any restrictions that we need to know about that?
So you are allowed to run a motor vehicle report and the federal government states that it says it's allowed based on a person's character to run that information, even if someone's not driving for you. So it is another layer of looking at it. Sometimes we have some individuals that say, hey, I never saw the DUI in that county, but they had a DUI. Well, it was in the motor vehicle report, but it didn't make that county. So we do see that at times happening, and that's really important always to take into consideration.
Great. Thank you, Alan.
You're welcome. And yeah, keep the questions coming. We definitely want to make sure that we answer all those questions. From a common name, also, as we talked about before, John Smith may come back with 60 cases because everything's by first and last name at the courts. So then we have to get that information as quickly as possible to make sure that it is that individual, going back to those courts to pull that information at times. So that sometimes can delay something by a day based on the fact of having to look at that information if it's a common name. And also those that are on databases, sometimes the database goes down. In Bahama, California, for instance, a disgruntled employee brought their database at the courthouse, and when they finally got it back up and running, the news article was, great news, we have it back up and running, it's only going to take 5 to 6 business days again. Thinking that that's quick when we're trying to turn it around in 1 to 2 days. So, again, it also goes back to the mercy of the court. And then, most importantly with verifications, there is a seasonal lag time over summer months and winter months, of course, when administrators' offices are closed to pull any education verification because we're going directly to the source. If they're closed for a week, we have to wait till they open back up. So those are seasonal based on verifications. Now going more into compliance and trends overall in how to reduce risk, because this, after doing this for 17 years almost now, at the beginning when I first came into this industry, there was not that much litigation. It was usually a one whistleblower in some organization that named their background screening firm and their company in a case, and it made the news maybe once every few months, if not every 6 months, we'd hear something. That has completely changed for what we see in the news. We're seeing it, Bill, as you even stated, it's a hot topic. It's coming in the news because, of course, we're following the news every day. We see on a daily basis something making the news for some company that's unfortunately at a high risk in class action lawsuit. A lot of that, so over the last 3 years, we've seen a 30% increase in the federal litigation, 10% over the last year, which we'll talk about in a moment. Nearly 1/3 of the U.S. population, or as many 100 million people, have some kind of criminal record. So again, due to the fact of how many people have criminal records, of course, the federal government wants to protect them to at least have the option and opportunity of getting a job, which makes sense. So there are more and more laws, and not only are there more and more federal and state laws, but there are more fragmented municipal laws, such as with ban the box of that question, have ever been convicted of a felony or misdemeanor, that we'll talk about at the end coming up. So it's really important just to know the consumer reporting laws and how they can affect you, which we're about to go over. The settlements that we see on average are 700,000 to 3 million in class action settlements. So they're big numbers, and lawyers know this at private firms, and they are looking for these types of cases. It used to be the tobacco industry that was sued so much. It's now the consumer reporting industry, the background screening industry, that's sued significantly. This is just a graph that visually shows you on how many federal lawsuits there are. So you can see, and this just pertains to background screening. So it has gone up dramatically, and we want to make sure that you are protected. And by following what are on these next slides, you will reduce your risk dramatically, because these are really the areas that are hitting most that we read about in the news on a daily basis. First and foremost, in April of 2012, the EEOC came out with what they called their guidance factors. Now, they're not really guidance factors, they're requirements, but they call them guidance factors. This was due to something that happened in the news where a background screening firm fraudulently conducted 660,000 supposed background checks for the government, but they never really did them. it was during the Snowden trial and Navy shipyard shooter, they never had background checks. So that made the news and made the federal government come down really hard on background screening firms and organizations to make sure that they were doing the proper screening. So by following these key factors, we'll really help to reduce risk, because in almost every case we see these types of items mentioned, which is A, look at each individual for the nature and gravity if they do have an offense. Is it job related? What's the severity of that offense? How long ago did it occur? And is that person a repeat offender? Is that candidate a repeat offender? And also, don't put in any newspaper article for the hiring of that individual, if you have a felony, we're not hiring you, immediate disqualification. Even if that is a disqualifier, by putting it in a no hire rule can end up in litigation, because you should always look at that individual for who they are and then make a decision, not with a blanket policy. So reduce risk, to reduce risk, make sure to speak with your legal, look at everything by a case-by-case basis, and also you'd want to make sure that anyone who is conducting your background screening is trained the same way, the same standardized way. And even talking more about standardization, you want to make sure that you have a package, a standard package that you run for maybe a specific job position or for your company, and that will reduce any perceived discrimination instead of picking and choosing what you want to run for each individual, which can be seen, of course, as discrimination. So you want to keep that process consistent, yet at the same time look at each individual as a case-by-case basis for what they have on their record and if that's related to that job. We also get a lot of questions about drug testing. Of course, in California being one of the states permitting usage, it's really important to understand that there are municipal laws, there are state laws. It's changing very, very quickly. I do have to still say, based on federal law, which supersedes state law in most cases, employers can still enforce a drug-free workplace zero tolerance policy. It still holds up. However, initially over the last few years, the first laws were to decriminalize marijuana. They weren't employment protections. Now we're starting to see employment protections in Massachusetts and Rhode Island. California has a law as of last year which prohibits employers, as you see, from considering non-felony convictions for possession of marijuana that are more than 2 years old. So there's that law, but we do believe that eventually there will be employment protections federally over a period of time. It's going to happen state by state and sometimes municipality by municipality. So you just want to make sure to check with your legal about if you do have a drug-free workplace policy or drug policy and you're doing drug testing. To go over more about the forms that you need to use, this is one of the #1 areas that's litigated that we see the most class actions about. There are really only 3 forms you need to be in front of that are really important to make sure that you understand and that you're using so you can reduce risk of litigation. The first one is, anytime you're conducting a background check on any candidate, you need to make sure that you have a state and federal compliant disclosure and authorization form, that the candidate is signing that you can conduct a background check on them. It's extremely important that they're signing off that they understand that. It's also important to understand about those forms, because this is where litigation is high, that there's no extraneous language on that disclosure and authorization form. That authorization form needs to have specific state and federal compliant language that your background screening company should provide you. For instance, we provide a sample form that our clients can use that's state and federal compliant. And also, it has to be solely of the disclosure and authorization form, meaning that it cannot bleed into the application, or it can't be with other, it can't be on a document that kind of announces the disclosure and authorization form on the same document versus being on a separate piece of paper for them to sign, or if it's online on an automated solution, that it's its own page on the web to review and click through. So that's really important, as you see in many of these cases for the millions of dollars by known brand name organizations. But it is getting worse and worse because even large organizations, their legal is not checking into proper disclosure and authorization form. So the solution to reduce risk is to use a compliant and separate disclosure and authorization form. Keep it pure of the legal language that's needed. Don't add any additional language. And again, your background screening firm should have that language. And always make sure that that form is signed either on paper form or electronically prior to conducting the background check. Really important. The second form is called the Summary of Rights document. So the FTC originally created this. Now they handed it off to their subdivision, which is the Consumer Financial Protection Bureau of the FTC. And that document is giving candidates an understanding of where they can call if they have identity theft, all the credit agency information, and their rights. Now, this document only needs to be given to a candidate if you're potentially not going to hire them, which we call adverse action, and we'll talk about that in a moment, or if you're conducting verifications on them within 5 business days, or excuse me, within a few business days of conducting the verifications. We just find as a conservative approach, just give them the document up front. Because if you're giving them the document when you're conducting a background check, at least you already know that they have the Summary of Rights document. Again, your background screening company should have the Summary of Rights document. You can also download it from online. But it's easiest just to give them their rights right up front, even if one of those 2 requirements is not needing to be met, such as that you are going to hire them. It's just better off to give them this document up front. And again, we can talk more about that offline if you have more questions about it. And the last form, which is really important if you're not going to potentially hire someone, is called adverse action, giving the candidate a right to dispute their information. So adverse action is in place by federal law because, of course, the government's concerned about the fact of someone having a false positive and not getting a job, since, of course, data from a credit header could be wrong. Or from even a county or from an enforcement officer reporting it, or someone, again, falsifying who they are. So it's really important to give the candidate a right to dispute their information and not just say that they are terminated or no longer a candidate just because of what you see on a report. It's really important if there's any influence of you potentially not hiring them, that you follow these adverse action processes, which we're about to go over, to give the opportunity for the candidate to dispute that report that came back. These are the 4 easy steps that are really important to follow if you're not going to potentially hire them due to what you see on that report. First is to notify the consumer with an adverse action letter, a pre-letter, which your background screening firm should have and provide you. Second, provide a copy of their report that has, influenced you to potentially not hire them, and their Summary of Rights document that we just talked about, that 1-page document that gives them their rights as well as about the credit agencies and identity theft. Then you want to wait a reasonable amount of time. Now, the word reasonable is used by the government, which is always a concern to us because what does that really mean? What we have found it to mean over the years with FTC letters that have been sent in and answered by the FTC, which then goes into pretty much law of when they answer them, is that anywhere from 5 to 10 business days is a reasonable amount of time to wait before sending the final notice out to them. This pre-adverse action notice states to them, you may not be hired due to what's on your report. If you have any questions, please contact the background screening firm, and gives the background screening firm's information. For instance, we have a dispute hotline where we will take that dispute and then proactively reach out to our clients if there's a dispute. There have been cases. Last year, the U.S. Postal Service had a case against them because instead of waiting 5 business days between this adverse action process, they only waited 3, saying that they waited 5, and that ended up in class action litigation. Uber also was firing drivers without giving them a chance to dispute the information, which ended up in a $7.5 million settlement. So the settlements are huge. So you want to make sure you follow this process, which is a very easy process to follow with these 4 steps. And if the candidate does not dispute the information within that reasonable amount of time that you set, then a final adverse action letter is sent out, which again, your background screening firm should have that letter and the language that should be on that letter. You again send them a copy of the report and their Summary of Rights document, and now you can rescind that offer. It's a very important process. Every employer has to follow this if you're conducting background screening and if you're influenced by that report, to give the candidate a right to dispute this information. And again, if they do dispute it, as I stated, your background screening firm would be notified either by you saying that the candidate's disputing it, or the candidate reading that letter would notify, because the background screening firm's information is on that letter. They would call a dispute hotline. You'd be proactively updated in that dispute as it's resolved. The government states that you have to wait 30 days to leave that requisition open, which of course is a long time when you're trying to hire someone in a position. Your background screening firm should act with urgency. For instance, we know that we finish ours within less than 5 business days to any dispute that comes in. And of course, they're more rare to come in, but they do. And then the correct language or updates or whatever else that needs to go on would occur if there was a dispute that was real. A good, for instance, that has happened was that one twin used his twin's information, and fortunately, the firm sent out the adverse action notices. That candidate disputed the information. It was found out that their twin used their information, and then the report was updated based on that information. And the federal law does this because of the fact that it knows that courthouses sometimes make mistakes and information is incorrect, or common names are incorrect. So again, it is a very important process that is heavily litigated against, and you can reduce your risk by following these steps that we just went over. We're almost finished, but just a few other items. Employment credit. We know that if someone can affect you financially, it is something that you may want to run. Employment credit. It does not ding their score. It is basically the credit header information. It's really important, as you see in all these state laws that prohibit using credit, to understand your state laws. All of them have exemptions. For instance, almost for anyone who's hiring a CFO is allowed to do employment credit, but you'd want to know your state laws and all the exemptions of what will allow you to do if you are using employment credit. You definitely don't want to use it on everyone within the organization, because that would be seen as discriminatory. And you want to make sure, again, that there's a reason why that you're running that on them, and speak with your legal about that. There was an important case back in 2014 where the EEOC started really heavily litigating against organizations using employment credit, but they lost the case against Kaplan Schools. The judge said that the statistical impact was unreliable that the EEOC was using, which led to other case law in favor of employers able to use employment credit for the proper purposes, which is good, because for a while, employers were scared to even use employment credit, even when it was seen as a necessary thing that they wanted to run on, for instance, a CFO job. So again, know your state law and talk to your legal about best practice there. One of the biggest areas that we get asked about is ban the box. The question, have you ever been convicted of a felony or misdemeanor on an application? Years ago, that's what everyone did. They had that question as a standard. It has changed over the years, in the last few years, a lot, with 150 municipalities and 30 states having their own state laws, with over 20% of the population living in a location that prohibits private employers from inquiring about an applicant's record at the start. The key term is at the start of the hiring process. So not only do we have this law with 150 municipalities and 30 states and having their own laws, but then they added additional laws onto this main law that deal with those EEOC guidance factors we talked about pertaining to background screening. And we'll talk about that in a moment, specifically about California. Obama also had enacted a federal law with government employees having that question asked at the end of the hire, not at the beginning, to give candidates an ability, if they do have a case, to go through at least the hiring process if they're a good candidate. So there is a federal law for government employees that was enacted last year. What's important to know is that California has their own laws, which is back in 2013, for any public organization, there's a law in place to remove the question. And also, it's been enacted with the EEOC factors, those guidance factors, which now are in law about looking at the individual, their job, how long ago did it occur, are they a repeat offender? That's now in law, not just a guidance factor based on this assembly bill. So that's California based on the questions of asking about convictions. Then we have the county municipality bills in different counties that prohibit different items. So most of them, like you see here, Berkeley, Carson, Compton, and Santa Clara, Pasadena, and Richmond. Most of them state until a conditional job offer is made, you should not be asking that question, have you ever been convicted of a felony or misdemeanor? You see that some of them are for private, which is Alameda County, Berkeley, East Palo Alto, Oakland, and Los Angeles, Sacramento, and San Francisco. It's really important to understand that these laws, you want to make sure that you are talking to your legal about when you ask that question, have you ever been convicted of a felony or misdemeanor? Most do include the EEOC guidelines we went over, and again, you'll have a copy of this so you can use this and ask any questions too after we go over this information. There's also a bill which is 1008 that was established last October in California, which prohibits an employer from engaging in various defined forms of discriminatory practice, where you cannot ask about a conviction history until an applicant has received a conditional job offer. Again, going back to that. Also looking at the individual as an individualized assessment, which is those EEOC guidelines we went over. It's also important to know that this law also stated that you have to provide an applicant written adverse action notice, where it's 5 business days to dispute and 5 more days to respond, meaning that you should wait conservatively 10 business days between the pre-adverse action notice and the final adverse action notice to be take the most conservative approach to reduce risk of any litigation. You'd want to check with your legal, or we can provide you more information on that, but that is one example of where the ban-the-box law led to other background screening specific laws within that bill, which we see quite often. There are certain positions that are exempt from the provisions of this bill in safety sensitive areas, which again, you can download that bill and take a look at it if you want your legal to take a look at that. It's mainly in healthcare and law enforcement that are exempt from this following this. And last but not least, as a trend, we know that a lot of you use social media. Way over 70% of employers look at some point at Facebook or LinkedIn or something about the candidate online. The FTC does approve this, but it's still the wild, wild west. We do believe that at some point there will be a class action against either EEOC or a federal or an ADA violation based on how individuals are using social media, even though, again, the FTC approves it for consumer reporting. There was also a study and survey that found that Blacks and Hispanics might adversely be impacted by the use of Facebook ratings, which tended to favor female and white applicants. We do believe we're going to see more of these discriminatory studies, and the laws are going to become much more strict. One way that we've heard of organizations reducing risk is by having a filter person that does not do the hiring, that filters out any social media concern specifically. So if they see that someone is talking about violence and acting out aggressively and having a gun, yet they also had cancer, of course, just the violence part would go to the hiring individual from the filtering person who's not doing the hiring, not talking about the cancer of that individual. So that's really important, just to put something into place and talk to your legal about best practice to reduce risk. Because again, this is one of the open areas still that we know that there'll be more litigation in the near future. And with that, we'd love to take more questions that you may have. And again, there is a downloadable PDF, and look forward to hearing some of your questions.
Alan, thank you so much for all the information. I think that what really, really stands out here is that there's so many different components to background screening, and so often the question, I know, comes to us here at Employers Group, hey, what do we need to do for background screening? What are best practices for background screening? But there really are a lot of different pieces that we need to look at, and I think that this past hour has really been useful for all of us to understand it a little bit better. And I really appreciate all your insights. We're getting a couple of questions coming in, so I hope anybody who does have questions, please, this is a perfect time to type them in, and we'll make sure they get addressed. We'll even linger a little bit longer if that'll be helpful for everybody too. But one question that did come in is about Medicare condition of participation. I guess if you're a hospice and have to follow Medicare conditions of participation, how would that work? What would your recommendations be on that relative to state restrictions?
Sure. So with any healthcare organization or those that work with healthcare organizations that receive any federal funding, there are specific services that we didn't talk about today that we many times talk about in our healthcare presentations, where there are sanction lists that we conduct called OIG and SAM GSA, which are sanction lists of healthcare workers that do have cases, and if they are on those sanction lists, they cannot be hired and need to be let go, due to the fact that if the Office of Inspector General or the Department of Health and Human Services finds out that they are working, federal funding can be taken away, and the average case that of a hit is usually around $120,000 as a start for a single individual that had sanction on them. So we can conduct those types of criminal searches that are specific to healthcare on individuals. And the best recommendation is that we do rescreening, which we didn't talk about today, which is becoming much more popular now, of course, even just in any industry, because when someone's working for you for X amount of years, if you don't do any rescreening on them, it's possible that they did do something while working with you, even though they were clear when they first started. So we do see organizations rescreening their candidates 1 year, 2 years, every 3 years. That's really up to you and your legal. In healthcare, it's even more important because there's a requirement with Medicare, Medicaid that we are running those specific searches as part of the requirement.
And Alan, I would imagine there are a couple other industries as well. Healthcare, I would imagine in education when you're dealing with anybody dealing with kids
right.
in a environment, government contractors, federal contractors, subject to OFCCP requirements. There might be some nuances that we need to think about.
Yeah, absolutely. And you can always talk to you can always talk to us. I was going to say, you can always talk to your background screening firm about, the industry you're in and what is best practice. We always, of course, defer to legal because there are so many, it becomes very tricky for us in the sense that as a consumer reporting agency, we know the laws backward and forward in consumer reporting, but when we look at each industry, even within each industry, there are specific positions in each industry, in each state that may have their own separate laws that are addressed specifically in a niche market that your legal would know more about than us, but we can definitely manage the package that you want and can, again, help out with whatever we can help out with. The general industries we know backward and forward. I mean, healthcare, especially in education, with education, you have parties at risk. So, of course, you want to be running the sex offender registry searches, which is not, one question that we had recently from a school system is, well, we were just told by our background screening firm that if we run the county, we already have the information. We don't need the sex offender registry search, which is definitely not the case. What's important to know about the sex offender registry search is that what we find from a pattern with sex offenders is that after they get caught and register in their state, then they move and change their name. Now, if we're running all names for a sex offender nationwide search, we'll still catch them, even if they don't re-register, because we'll find out where they registered originally and running all their names too that they've used as alias names, because that is common, and we want to make sure that we catch everything.
Yeah, it's really interesting. I'm glad you brought that up too, because it's like a lot of the challenges that we deal with in human resources between city, state, federal and different municipal guidelines and requirements now, you really have to be thorough, and you have to make sure you're checking all of those boxes when you do this research. So, Alan, thanks so much for really giving that particular area special attention. I think that's really eye-opening for a lot of us. I think that Alan's done an absolutely fantastic job of really getting us to understand how this ties in, how significant this is. And, you know, when we look at the employee life cycle, really understanding that it begins well before that first day of employment. So I want to make sure as we close today, just to encourage everyone to reach out to your friends here at Employers Group with these questions, reach out directly to Universal Background Screening with some of these questions. Either way, let's make sure that we're talking to you and that we have an open dialogue with all of you on these issues, because you look at the numbers that are coming up in litigation right now, and that's pretty scary. And it just starts with not having the answers, not having the information up front. And you can see you can tell from listening to Alan and everything that we're talking about here, this information is readily available. You have your friends here at Employers Group, you have your friends at Universal Background Screening. We are all here to support you in every possible way. There's a couple of other questions that have come up that I'm going to have addressed through Employers Group's helpline that are not directly related to the background screening questions, simple questions, but I want to make sure that we will get everybody an answer to every question that has come in. But I wanted to make sure we keep Alan focused on the ones specific to background screening. And Alan, as we close, I want to thank you again and everybody at Universal Background Screening for the great job that you do for everybody, and of course in particular for our members and our friends from Employers Group. So thank you.